Good afternoon, everyone, and welcome to PUL342. Today we are on to topic 4, and we shall be looking at other types of offenses against public order. Remember the other time we mentioned some offenses against the state and even against public order, wherein we dealt on treason, we also dealt on sedition and the like. And then today, we're going to look at other types of offenses, but basically this time around, we're going to look at offense against public order. And in this slide, we're looking at unlawful assembly. We're going to look at we're going to look at unlawful assembly. We're going to look at riots and also arson. And if time permits, we shall be looking onto perjury and contempt, which are offenses against the administration of justice. So to do this, I shall be sharing my slides. And while I do that, please take down your questions. If midway you really need to ask a question, please call my attention to it and listen carefully. Thank you. So like I said, today we are going to be looking at offenses against public order. And we shall start with unlawful assembly. Under the provisions of the law, certain offenses are regarded as offenses against public order. And one of such offenses is unlawful assembly. When we say people are gathered unlawfully, what do we mean? Under the criminal code and penal codes, these offenses are meant to prevent the breach of peace. They are there and they are patterned after the common law. And such offenses include, like I said, unlawful assembly, riot, and the likes. And basically, they relate to preservation of public order, to ensure that the public is safe, to ensure that everyone is safe. Such public order offenses are therefore created to combat conceivable situations of public order problems. Now, it is expected that at the end of these topics, or at the end of these subtopics, you are expected to know what the offenses are, what acts or what element constitutes them. You're also expected to identify the various types of elements under them, like I said before, and also to know the potential danger posed by some of these offenses to the exercise of fundamental rights of the citizens. Like in that of unlawful assembly, as we go ahead, we will find out that even though there is a provision for it under the Act, it is at the end of the day unconstitutional, going by the provisions of the Constitution. And so to that extent, such acts have been decreed or have been proclaimed null and void. So basically, let's look at what is unlawful assembly. Now, Section 69 of the Criminal Code defines unlawful assembly as where 3 or more persons with intent to carry out some common purpose, assembled in such a manner, or being assembled, conduct themselves in such a manner as to cause persons in the neighborhood to fear on reasonable grounds that the persons so assembled will tumultuously disturb the peace or will by such assembly needlessly and without any reasonable occasion provoke other persons tumultuously to disturb the peace. They are an unlawful assembly. So what are we saying here? Is like in the provisions of the penal code under section 100, it provides for 5 or more persons. So the important thing is that definitely one person cannot be enough to constitute an unlawful assembly. It won't be between 3 and more or and above. So when they are gathered in a particular place and all of that, and it's not just their gathering that matters, their conduct also is very important. How have they conducted themselves? If they have conducted themselves in the neighborhood in such a manner that people around, are disturbed by their gathering, people around fear their gathering, people around are uncertain of what their gatherings are all about, and being so assembled, they disturb the peace of the place. Of course, such assembly will be deemed to be unlawful assembly. So the following circumstances will suffice, like I've said, for unlawful assembly. What are these circumstances? That such persons bear arms, dangerous or offensive weapons, display functional emblems. Like I tend to see some group of people maybe going around carrying flags, this and this must be, displaying all kinds of weapons and all of that, just clearly to show that they are whatever they are gathering is for is to disturb the peace of the area. If by their conduct, though marching, chanting songs may become through the kind of songs they are saying, chanting and all of that, it might also result in an unlawful assembly. Again, if the reason for the gathering would definitely constitute a breach of the peace, for instance, because they have gathered, there are people seeing them in such a manner, looking so scary, everybody start closing shop, everybody start running away back to their homes. Such an assembly, of course, could constitute a breach of the peace. Like I've said, the offense is provided for under section 69 of the Criminal Code. You also have it under section 100 of the Penal Code. So it is also possible for the assembly to become unlawful if though initially for a peaceful purpose, but with time you see everybody becoming very rowdy, very chaotic, and becoming very, very irresponsible. So such an assembly, of course, becomes very, very dangerous. The punishment for taking part in an unlawful assembly under the Criminal and Penal Code is imprisonment for 1 year. So having said that, it is also important that the assembly need not be in a public place. So where 3 or more persons with intent to go out and commit acts that endanger public peace, it is unlawful assembly. So if, for instance, maybe the initial assembly was not in a public, maybe in a private setup, but they are going out with placards, with leaves and all of that, with intent to cause mayhem, that can also be declared to be an unlawful assembly. So while basically the essential ingredient of the offense is apart from the gathering, is to disturb the public peace. The offense of unlawful procession commences with an unlawful assembly with intent to disturb the peace. Of course, we've seen a lot of processions that we know that normally maybe it started, and before you know what's happening, the unlawful assembly has turned into a procession, and it's very, very rowdy, and there's fear, everybody's running, scatter, trying to leave the place, and there's violence everywhere. So it is important that it must be proved that the person's intent to use or abet the violence, or that the person which does or abet acts which to his knowledge is likely to result in the disturbance of the peace. So this is the case of Ogeni and IGP. Now, it's necessary we realize that the circumstance of every case will most times determine whether the presence of people in such a particular life will constitute an unlawful assembly, such as the manner in which they conduct themselves. This is what I've been saying. So it is not just gathering together that is the problem. No, people can gather together for whatever they want to gather together for. But it's the manner they conduct themselves, the way the gathering later turns out to be. If, for instance, the gathering is now seen as something that will be, if care is not taken, before you know, everybody is in danger. Or if they are armed with claws, weapons, and the kind of languages that comes out of them, you will be able to tell that these people are definitely out for problem, or definitely out for all kinds of things. So the unlawful assembly under the Public Act, remember I told you earlier that there's a Public Order Act that prescribes for unlawful assembly, but which with time has been declared null and void to the extent of its inconsistency with the provisions of the Constitution. So now, a law hitherto regarding assembly, meetings, and processions in Nigeria was the Public Order Decree of 1979, which repealed all public order laws in the states of the Federation and replaced them with a federal act for the purpose of maintaining public order, among others. On the return to civil rule in 1999, the law was then codified as an act of the National Assembly and designated as Public Order Acts, Laws of the Federation of Nigeria 2004, now 2011. Under the law, The governor of each state is charged with the conduct of all assemblies, meetings, and processions of public roads and places in the state. Note, it is the governor that is mentioned under the provision, not the police officer, not the commissioner of police. So anyone desiring of conveying any assembly or meeting or of forming any procession in such place must seek a license or obtain a license from the governor not less than 48 hours thereto. Now, this is what we're talking about. Agree that the governor is in charge of all conduct of assemblies, meetings, and processions on public roads and places. But the issue of getting a license, obtaining a license from the governor and all of that, how relevant is it in considering the provisions of the Constitution and also some relevant cases? Like the case here of All Nigerian People's Party and IGP is a case in point. We also have the case of COP and Attorney General of Anambra State, and also the provisions of the Constitution in Section 215, subsection 1, which provides for the governor of a state, of any state of the federation, being in charge of all assemblies or meetings or processions of public road. These provisions of this Section 215 to the effect that it's only the governor that has such a mandate. It's not the police officer or even the commissioner of police. However, the governor may delegate his powers under the act to the commissioner of police in relation to the whole state or part thereof. Now, provision was made for a person agreed by the decision of the commissioner of police or any superior officer to appeal to the governor, who may require the commissioner to give a decision on any appeal, but the decision of the governor shall be final. Now, the issue here really is not about the governor being in charge of all assemblies or whatever. The issue that has raised a lot of controversy is that of a license that must be given by that must be issued before such procession can take place. Before we go into that, we should note that penalties are imposed for any assembly, meeting, or procession which takes place before a license or whatever is being issued. Now, like I said before, the Public Order Act has been a controversial law in Nigeria, as some have alleged that the police use the law to harass, intimidate, and brutalize innocent Nigerians in the process of protesting unpopular policies of government by using excessive force against them, arresting and or prosecuting their lawfully engaging in peaceful protests or rallies. We all are all witnesses to what happened last year during the NSAS, what led to the NSAS, and how at the end of the day, the NSAS matter became so, what many people didn't anticipate would finally end up, will finally be the end of the NSAS. Until today, the matter is still not yet finally resolved by the court. So we're still waiting the final outcome of that matter and how it will finally lead up. But suffice to say that the law has been viewed by many, that this law of having to obtain the license before carrying out a peaceful protest has been viewed by many as infringing on the right of Nigerians to freely assemble and associate with other persons contained in Section 40 of the 1999 Constitution, and of course, Article 2 of the African Charter on Human and People's Rights. Although the provision of Section 40 is subject to Section 45, subsection 1 of the Constitution, that permits any law that is reasonably justifiable in a democratic society in the interest of defense, public safety, and public order. Okay? So what this is saying is that, yes, every person is free to associate freely, just to assemble freely, and all of that. But it is still subject to Section 45, subsection 1 of the Constitution that provides for public safety. In the process of carrying out your process, you must not disturb the public peace. You must not disturb the public order. You must not do things that are contrary that will bring upon you the law enforcement agent. So this led the Court of Appeal to affirm the lawfulness of the Public Order Act in Louis Chukwuma and others versus Commissioner of Police. However, notwithstanding that decision, it has been contended that it is only in cases of emergency of assembly can be restricted, and that the provisions of the act, especially that of requiring people to seek and obtain license from the only before people can freely assemble is antithetical to a democratic society, as it places a lid on the exercise of a right guaranteed by the Nigerian Constitution. This is what we've been explaining so far, and of course, we know that that is not, that definitely will not be. So it is interesting to note that in the case of IGP and ANPP, the Court of Appeal sitting in Abuja struck down the Public Order Act, struck down the Public Order Act as infringing on the fundamental rights as guaranteed by the Constitution. The court held that no individual or group of persons require a police permit or approval to hold rallies and peaceful assembly, and held that such will be in conflict with the provision of Section 40 that guarantees for free association, free assembly of the Section 40 of the Nigerian Constitution. Interestingly, also a case in Ghana by the Supreme Court in New Patriotic Party versus IGP has also nullified the Public Order Decree number 1972 of Ghana that requires people to obtain police permits before embarking on a public procession. So we can see that this is the position of the law now, that you do not need a permit or whatever to embark on a public procession. So that is about the public unlawful assembly. So it is, you can gather, yes, but such an assembly must be subject to Section 45 of the Constitution. It must be, it must be peaceful, it must be orderly, it must not be to attack or break the public peace. Because when that is the case, of course, then you leave the law enforcement, give them no other option than to come in and do what they have to do. So as we speak now, going by the provisions of the law, going by judicial authorities, we do not need a police or a permit or a license before a lawful assembly can be held. So we've looked at what it means to have an unlawful assembly, the essential ingredients that are necessary, and the like, and of course also the punishment as prescribed under the provisions of the law. Now, we shall look at, I don't know whether we have any questions. Does anybody have any question to ask? Good. So we shall look at another offense against public order, and shortly we shall look. We shall look at riot shortly or briefly, basically to say that it is an unlawful assembly that has generated into violence. So we can see that where an assembly is deemed unlawful by the time it has started generating into another thing. By the time that is gathering or the conduct of the person is becoming worrisome, by the time that it's portending stress or trouble for those around, then of course it's becoming very, very unlawful. And by the time they now become violent, become riotous, of course, that is now no longer an unlawful assembly, but even riot. So riot is an aggravated unlawful assembly. It's something that has generated into violence, involving acts of violence by one or more persons, which constitute a clear and present danger of or shall result in damage or injury to the property of any other person or to the persons of any other individual or threat to all. So we see that riot is a full-scale or it's a aggravated unlawful assembly that are degenerated to another kind of thing, presenting danger to all those around. And the relevant sections are Section 71 of the Criminal Code and also Section 106 of the Penal Code. The punishment is 3 years with fine or both. So under Section 70, it is being defined as when an unlawful assembly has begun to act in so tumultuous manner as to disturb the peace, the assembly is called a riot. And the people assembled are said to be riotously assembled. So we can see that it's an aggravated form of unlawful assembly. So Section 105 of the Penal Code defines the offense as whenever force or violence is used in an unlawful assembly, which is essentially the same as that defined by the criminal code. So in the end, the two codes are in the same line with the same definition for the offense of riot. So the congregating of about 500 people who are armed with weapons on a public highway, singing and chanting and constituting obstruction to the public highway, and refusing to leave when asked to do so by the police was held to be a riot in the case of R and Aaron. Also, the stripping and beating of someone in a public place by some other persons who came together for that purpose was held to constitute a riot. Again, this is the case of Adebi and the Inspector General of Police. However, like we've done, we've been able to distinguish unlawful assembly from riots. In that, why riot needs the actual use of violence, what the actual use of violence, unlawful assembly, basically, you need to create fear, that in the people around, maybe because of the conduct, because of the way they are carrying out themselves, and also the assembly should be such as is disturbing the peace of the area. So while one might not necessarily have used violence or whatever, but their presence alone, is enough to scare everyone away. So riot itself is basically the use of violence. Even why assembly, unlawful assembly is not necessarily the use of violence, but the gathering in such a way, conducting themselves in such a manner as to create fear in all those around them. So another offense which I've been looking at here is affray. Affray is like fighting also in a public place, or it could be even in a private place. So it's a public offense as common law. It is the mutual combat of two or more persons to the terror of the people. Again, this is fighting. One of the you see two people fighting. The next thing, they've carried bottles and started hitting themselves and all that. You see everybody around them, giving them way and running away. So the difference between it and the riot is that riot is a planned action. People have planned that today they are going to do this. They are going to disturb the peace. And in disturbing the peace, they are going to do it riotously. They are going to carry weapons. They are going to destroy things. Affray is not premeditated. Fight does that. And you don't see yourself having to either wanting to defend yourself or to do one thing or the other in order to get that. So what is essential is that it could be in a private place or publicly, get that, understand that. It doesn't necessarily have to end up in a public place. But the members of the public, for instance, you could start a fight in your compound, but before you know, it's already it's already stretching out to other people around. The kind of things that are being used. Maybe you started using bottles, gunshots, stones, and these are all flying around you. So it must be able to have something that's able to terrify the public, as the case may be. So it was also the time that members of the public have access at the time of the affray by right, license, or permission, as the case may be. So that is it. So a few questions I have here before we go into the other aspect is, what are the similarities or differences between the offenses of riot and affray? Are there similarities? Remember what we've been discussing. Are there differences? Of course there are similarities. Of course there are differences between the offenses of riot and affray. 2, what are the essential elements to be proved in the offense of unlawful assembly? What are the essential elements to be proved in the offense of unlawful assembly? This again, we should be able to discuss from all we've stated above. Bring out the essential elements where 2 or 3 more people are gathered with intent to disturb the public place and conducting themselves in such a manner that raises fear in the neighborhood. Those are all some of the essential elements. Now, there's a problem question I have here, which states that people numbering about 320 gathered at a public place to peacefully protest the planned total removal of petroleum subsidy by the federal government. The police swapped on them and arrested 50 of them on ground that they are likely to cause a breach of public peace. Now you have to advise those arrested on the legality or otherwise of the police action. What is the legality or otherwise of the police action? This you should be able to answer, having understood what the elements of unlawful assembly is. You should be able to answer this question with authorities, both judicial and statutory. So we'll move on now to look at some other offenses. Now, we're going to look at offenses against the administration of justice. Like I said before, we've been looking at offenses against the state and against public order, where we've just mentioned unlawful assembly, treason, sedition, riots, affray, and the likes. So briefly, we shall look at two types of offenses here against administration of justice. And maybe when we meet next again, we talk more on offenses against the administration of justice. So the two offenses we have here are perjury and the offense of contempt. So what's perjury? Basically, perjury is the giving of false testimony under any lawfully administered oath. Accordingly, perjury may be committed if false testimony or statement is made in a judicial authority or under oath before anybody that is authorized to administer an oath or witness who appears before it. So when you are swearing before the court that you tell the truth and nothing but the truth, and you go ahead to go and say everything wrong, you say everything except the truth, of course, that's an offense of perjury. So now, what are the provisions of the section that takes care of this? We have section 117 of the Criminal Code to section 118 of the Criminal Code. We also have section 156 of the Penal Code. It is important for us to note that under the laws, the offender cannot be arrested without warrant. When it is an offense or perjury, you need to issue an arrest, you need to have your warrant of arrest. Again, on a charge of perjury, the prosecution must establish that the accused gave the testimony complaining of knowing it to be false. Of course, this is very important. The accused person telling lies must know that he's telling lies and that what he's saying is not true. And that two, the lies he's telling is also important. It must be relevant to the fact of the case. For instance, if the accused person is being charged for stealing and is talking about talking about how he has 4 wives and all of that, and that might not really be relevant to the charge of stealing, So what is important that whatever he said that is deemed to be a perjury must be that is relevant, must be that is material to the facts in issue. So basically, the testimony must be false, like what we have said. The testimony must be said or must have been given in the judicial proceeding. It's not when he goes outside and he starts talking. He now say, no, what he's saying is like, no. What he testified before the tribunal, what he testified before the court, what he testifies before those that have been properly constituted lawfully constituted before him, and all of it doing so under oath. It is very important to know that it must be under oath. So it must be for the judicial proceeding and must be under oath, and also that he knew of the relevance. He knew that what he was saying was true or was not true. Again, what are the sentence or what are the punishment for this? Again, under the Criminal Code, the punishment prescribed for perjury is normally 14 years. But where the perjury is procuring the conviction of another person for an offense punishable with death or life imprisonment, the punishment is false. For instance, where you have given testimony that you know is fake and has led to the conviction or punishment with death of another person, of course, that your testimony that is false will result to life imprisonment for you. So for cases you can read also is the case of Omorege and DPP, which is very instructive on this offense. Then lastly, we shall be looking at that of content. When we talk of contempt of court, what are those things we have in mind? In Alake and the Attorney General of the Federation, the court described contempt of court as any conduct which tends to bring into disrespect, scorn or disrepute the authority and administration of the law, or which tend to interfere with and or prejudice litigation and or witnesses in the course of litigation. So it is important that generally contempt of court is normally called contempt of court is seen as that which scandalizes the court. Anything that scandalizes the court, that brings the court into disrepute. Scandalizing the court here too might even mean scandalizing the judge because the judge represents the court. Okay, so it might not say, I didn't say anything about the High Court. I was only talking about justice. Justice A is the one that sits at the High Court. So when you scandalize him, you're also scandalizing that particular court. Now, what are some of the aims of contempt? The purpose of the law of contempt is in having the power to redress an act of contempt before is to maintain law and order. For instance, a lawyer going into court and shouting on top of his voice at the judge, or even insulting the judge, will bring about chaos in the court, will bring about disorder. So it is to maintain law and order. So an accused person shouting at the judge or at the counsel and saying or going very rowdy in the court. Of course, this will not be tolerated. Of course, another aim again is to uphold the dignity of the court by ensuring that the rule of law is upheld and justice is seen to be manifestly seen to be done. Also, to keep the streams of justice clear and pure, that parties may proceed with safety both to themselves and to their character. You see cases where people come to court ready to fight, ready to do all kinds of things. Okay, that is not allowed. That is not allowed under the law of contempt. So now, what are the classification of contempt? We have various types of classification. We have direct and constructive contempt. Direct contempt, of course, like going to court and then doing something that is wrong before the court, shouting, insulting the court, doing all kinds of things before the judge. Okay, and this can be dealt summarily. What do you mean by that? That can be dealt summarily. The judge before whom the offense was committed tells the person committing the offense, that's the contempt law, of the contempt accusation and asking on why she should not be found guilty of the contempt. Okay, the judge has found you wanted, and there, the trial has started and ends there. So such direct contempt can be dealt with summarily. Okay, so where the judge lacks a satisfactory answer, the court will enter judgment against the contempt and pass punishment. Individuals charged with indirect contempt must be afforded, but when it comes to indirect contempt, individuals charged with indirect contempt must be afforded an opportunity to prepare a defense and may be represented by counsel. So these are basically the two different. While one, it can be tried summarily there and there. The other one, you can be given enough time to go and prepare your case and come and all of that, be presented by counsel and all that. So that is one classification of contempt. It can be direct, it can be constructive. Then the also that the fact that constructive or indirect are those not within the court. Okay, we must also know this. Direct contempt, like I said, are those that are said inside the court, normally referred to as in-facial cruel. Before the court will commit such and so, while outside the court are those that tend to obstruct or defeat the administration of justice. And for instance, when a court order has been given and you refuse to carry out that court order, that's a constructive contempt of court, or it's an indirect contempt of court. It's also known as ex-facial cruel, that's outside the court. Such is being committed outside the court. Again, we have another kind of classification, which is between civil and criminal. So apart from direct and indirect contempt, we also have between civil and criminal contempt. Basically, criminal contempt differs from civil contempt in that criminal contempt is a violation of the criminal law. Okay? And while civil contempt, on the other, are sanctions available to court against persons recalcitrant to meet the court order. Like I said before, refusing to obey court order, refusing to carry out the orders of the court. Those are all forms of civil contempt. Now, criminal contempt consists of deliberate conduct calculated to obstruct or embarrass a court of law or conduct intended to degrade a judicial officer in administering justice. For instance, you are before the court and maybe your lawyer is saying something that you do not appeal or agree with. And you say, why did I pay you money? Did to come here and come and misbehave and do that? So of course the court will call you to order. The court will call you to order. And if you are not able to calm yourself down immediately, the judge can punish you there and there. Okay? Or when you see the judge and you tell the judge that he's already taking sides, and you can see that the judge is not prepared to listen to you, of course, those are direct contempt. Those are criminal contempt, you know. So criminal contempt harms the judicial process of itself. And again, criminal contempt can also be direct or indirect contempt. So like I said, direct contempt consists normally in facia, that is in face of the court before the very court, while the trial is going on. While indirect contempt, those are those, or constructive, those are those committed outside of the court premises. Okay? And most times too, that is why when a case is pending before court, people don't discuss on such cases. You wait for the outcome of the case before you start discussing the content of such a case. You don't discuss a case that is pending before the court outside. You wait to hear the decision of the court. If not, you could be punished for contempt of court. Now, I have a question here which I will want you to answer. The question is, with the aid of judicial and statutory authority, you have to differentiate between civil and criminal contempt. With the aid of judicial authorities, you have to differentiate between civil and criminal contempt. Again, we should know that even though the law contempt statutorily does not actually have a definite provisions under the code, but we have a lot of cases and all of that points to the fact that it is something that the court watches out for, and it's something that is punishable under the law. So we shall stop there today, and I want to believe that, or I will start sharing my slides, and I want to listen to questions. And when there are no questions, then we call it a day. Anyway, in the absence of any question, we will call it a day, and we hope to meet next week. Please, I want you people to be part of this class, because you will gain a lot by being part of the class. You ask your questions, we're able to discuss your questions, we're able to see how we can, some of those things that are worrying you, or some of those things that you're not clear about, you can ask questions on them, and of course, we'll be able to answer them. The essence of the facilitation class is to see those areas that, for instance, are not really clear to you. And then you bring them up. We're able to facilitate, be able to make it clearer, make it more understandable for you. I want to also believe that you people are still reading your course materials, you are going into your virtual learning environment space, and also doing all that you ought to do in preparation for your forthcoming examinations. Please do not take your lectures, your facilitation period, take them seriously as you can. It will help you a lot. So next week, look out for the link. Again, I'll put out a link for our lecture for next week, because we shall be going on to topic 5. This lecture, if you're not available, you can go to your virtual learning space and get it, or go to the link. It's a recorded session, and get it out and listen to it properly. If there are questions you have under it that you want to ask under our next lecture or under our next facilitation class, you can ask a question, and of course, we'll take those questions. So I want to thank you once again for your time. See you next week.